Delighted today that 50th Chief Justice of India, Mr. D.Y. Chandrachud, joins this series. Mr. Chandrachud, welcome to NDTV.
Thank you very much for having me here. Thank you.
Thank you so much, Justice Chandrachud. You occupied the highest seat of judiciary in the country. It is said that India's Supreme Court is one of the most powerful in the world because you have the jurisdiction over 1.5 billion people. What is the world like and India like from that position?
Tough question, but to be very honest, sitting in the Supreme Court, as I did for close to 9 years, you realize the complexity of the nation, the diversity of the nation, both in terms of the political units of a federal country, the diversity of of individuals, whether it's in terms of language, culture, religion, caste, region. And then when you look at India in terms of its relationships with the outside world, you have a different feel as a judge of the Supreme Court, particularly when you deal with important commercial cases. So really, to answer your question, being a judge of the Supreme Court is an enormously enriching position and task, because sitting there, you realize that India in that sense is brought together by a whole series of cultures and ideas, different ideologies which mold together in the formation of one nation. And in the conflicts which come to the Supreme Court, though they are individual conflicts primarily, and we also have conflicts between different governmental levels, but in the unfolding of these conflicts in the Supreme Court in litigation, you realize the depth of the country. It doesn't really represent, in that sense, one predominant view or thought process. It's this, the diversity of the nation, which I think presents itself very clearly when you decide cases in the Supreme Court.
Justice Chandrachud, you are son of a big gun. Your father was a longest serving Chief Justice of this country. Sometimes, when we measure up to our parents and we look back, surely we fall short. But how much did you learn from your own father, his experiences as the judge of the Supreme Court and then the Chief Justice, the longest serving one of this country?
Well, I learned a great amount from my father, though law was not my first choice, to be very honest. I graduated from St. Stephen's College in economics and mathematics. I did my honors in economics. And after I completed my BA, my first choice was actually to pursue a post-graduation in economics at the Delhi School of Economics. But as destiny would have it, I joined the law faculty and then there was no going back. My father, of course, was a very important source of influence on my life, not just in terms of the law, but in terms of learning basic values, the ethical values which are associated with life. That generation of judges and lawyers was very strong on their foundational principles. My father completed his law in the 1940s, in 1943-44, just a few years before independence. And that generation of people from the legal profession saw the law really being unfolded at the very foundations of the new nation state, the independent nation state. And therefore, in so many ways, I think they focused on the essentials of the law. Our generation is very different because, we are we are the post-independence generation. I was born after independence, and as most of us are. But significantly, I think, for us, we have seen the law unfold over the period since independence. My father was the sort of a person, however busy he was with his work as Chief Justice of India, and he too had very tumultuous times over which he presided as the head of the Indian judiciary. He always found time for family and to discuss a fine point of law or a fine issue of constitutional interpretation which was concerning his mind. But all in all, I think, yes, he was never dogmatic, and he was never very clear as to whether I should first join the law, and he left it entirely to me to choose a career path of my choice. And when the call of higher judicial office came to me, I was asked to become a judge when I was just 38 years old, and my appointment was not coming through for 2 years. And at that point of time, I thought that, well, it's time to get on with the law and be a lawyer for the rest of my life. And when I looked at him for advice, he said, do as you please and I'll support you in whatever you do. And perhaps he said, you will do equally satisfying work and fulfilling work as a lawyer at the bar. So he was never one to really impose his views on the family. He was that kind of a father. For me, truly, he was, particularly later on in life as we grew up, he was more of a friend than, in a position of a father-son relationship for me. And I think that friendship between us continued throughout his life.
And from whom did you learn the craft of this profession? I mean, I'm sure the profession is full of those crafts that you learn. Who do you owe it to?
You know, I really had the good fortune of belonging to a generation where some of the greats at the bar were still in very active practice. For instance, I worked very closely with Mr. Fali Nariman, and as a young lawyer from Mumbai, and before I shifted practice to Mumbai, even as a young lawyer in the Supreme Court, I would work very closely with Mr. Nariman. Something as simple as, crafting a good list of dates, that is the chronology of events when you present a case before the court, was what I learned from Mr. Nariman, because that contains your whole factual case before the court. I learned that from him. Or Mr. Soli Sorabji. Soli had the art and craft of being extraordinarily brief in his conferences and in his submissions before the court as well. I worked on very seminal constitutional issues with Mr. Soli Sorabji. Mr. K. Parasaran, when work was done in the Supreme Court in the afternoon, we'd go to the Constitution bench, which was the Chief Justice's court, when the court was relatively empty in those days. And I would watch Mr. Parasaran unfolding the Constitution with nothing else but the bare text of the Constitution in his mind, in his hand. And, it was sheer brilliance, because Parasaran never relied on authorities and past precedents to start with. He looked at the Constitution in terms of its bare text. And it was truly a learning experience to watch these greats at the bar. Mr. K.K. Venugopal, the former Attorney General for India. Venu was extraordinarily brilliant both in constitutional and commercial cases. And these were people from whom you learned a great deal at the bar. But there's a flip side to it as well. Much of the learning process at the bar and on the bench as well is about learning from your peers, because you learn on what you should do and you also learn about what you shouldn't do. Because, the bar consists of a motley group of persons. The bar doesn't have, it's a bar which is so diverse. There is the large base of the pyramid, and then it sort of tapers off as you go up to the highest echelons. But sitting in the court every day is the greatest learning experience, because in the dialogue between the judges and the lawyers, you realize what really makes judges tick. What is it that a good judge is asking for in a case? What is it that they are trying to fathom to arrive at the truth? And likewise, when you look at it from the perspective of a lawyer, you learn on how lawyers deal with the queries which come from the court. How do they handle difficult cases? How do they handle difficult opponents? So, the law in action in that sense is very different from the law as it is taught in law schools, because it's all about a human drama which is unfolding in the court. And since it's a human drama involving conflicting cases of parties, the people who participate in that drama, namely the judges and the lawyers, are those who really shape the outcome of jurisprudence.
So did the Harvard Law School teach you something extra? Because you say that law in action is very different from law in textbooks.
Yes, it did, because Harvard Law School really taught me very significantly the policy-oriented approach to law. The critical legal studies movement was just gaining ground at Harvard. Incidentally, I learned about a great deal about policy as a student of economics at Delhi University, and then also at the Campus Law Center in Delhi. We had great teachers like Upendra Bakshi, Lautika Sarkar, Shivramaya, who taught law and poverty. In fact, Lautika Sarkar gave us the first groundings in feminist jurisprudence, when people were not talking about feminism in our law at that time in the 1980s. But going to Harvard, I think I really profited very greatly by learning about the critical legal studies movement, which is now par for the course. Critical race theory, for instance, is very, very widely researched and spoken about. So going to Harvard in that sense was completely a different experience. But if you ask me what impact Harvard had immediately after I returned to practice, I have to confess that it's not that because you study at Harvard Law School that you'll get a little higher fee as a young lawyer. You are still at the bottom of the ladder. You are competing with everyone else who is at the same platform, namely a 1-year or 2-year-old lawyer at the bar. I realized to my disappointment in those days that when I got my first brief as a young lawyer in the Bombay High Court, I was fresh out of Harvard Law School. I had an SJD from Harvard Law School, which is the Doctorate in Juridical Sciences. And my first brief, which was a little docket to mention before a division bench of the Bombay High Court, I was given this docket. So I asked the solicitor, how much do I mark on the docket? I mean, in the sense, what is my fee? Fees in Bombay in those days were marked in GMs, which is gold mohurs. And, one gold mohur was 15 rupees. I believe the Calcutta GM was 16 rupees. So the solicitor looked at me and said, for this particular work which you are doing in the court for me, the ordinary fee would be 5 GMs, which would be 75 rupees. But since you are first appearing before the High Court, I will give you 6 guineas for this case. So I realized that notwithstanding a Harvard PhD, what I could mark in those days was about 75 rupees or 90 rupees in the mid-80s. So, well, life teaches you so many good lessons, and you realize that, a good academic degree is important, but it's not everything in itself when you actually join the profession. But Harvard actually benefited me as time went on, because the learning lessons which I received from Harvard, I was a student of Professor Lawrence Tribe, one of the greatest constitutional law scholars. And when I became a judge and started writing about the law and not just speaking about the law as lawyers do in my judgments, I realized what an imperceptible impact Harvard had on my way of thought as an individual. So a lot of things are not so perceptible when you first join the profession, but the impact of what you've learned emerges later on in life as life goes on.
The rigor of an academic degree, as they say, that's important in life. Let me take you back, Chief Justice, and let me ask you, you said you talked about the human drama in the courtroom, and you said the participants are important and that it's more of a participants' play. Is that drama closer to Bollywood, Chief Justice?
The Bollywood scenes about courts are very different from what actually happens in reality in the court. Yes, there is a drama, and at times there is quite a bit of drama, particularly in sensitive cases. But a lot of times what goes on in court is, in that sense, bare bone exposition of facts and law. So it's very different from how the court is portrayed in Bollywood films, or for that matter in some of the Hollywood films as well, or other films of a different genre.
Or by the authors like Sidney Sheldon?
Yes, I think so. Because, what happens in the court is that you are dealing with real life issues concerning citizens. It may be a criminal case, it might be a dispute between spouses, it may be a dispute between two corporate bodies, it may be disputes between, say, the state government and the central government. As in the Supreme Court, it happens so very often. So, the real work of the court is done with intellectual rigor. And that intellectual rigor also imparts a sense of confidence in the judicial process to our citizens, because they realize that there's serious work going on over there. Even if it's a case, say, concerning marriage equality, the actual argument is all about constitutional interpretation, and the rigor of the intellectual process in the court is, I think, which is something which sustains the confidence of people in the process.
And among your landmark judgments, sir, has been on the electoral bond scheme. You declared them unconstitutional and also affirmed the rights of voters to know the source of electoral funding. It would not have been an easy judgment to arrive at.
Yeah, actually, no. I would think that no judgment which a judge delivers, particularly in the Supreme Court, is easy in itself. Because when the Supreme Court speaks, it speaks for the future. It speaks for the present, and it speaks for the future. So, and there is no higher court above you. When we were in the high courts, we always felt that, sense of comfort that should I, as a human being, commit an error, I mean, you don't decide to commit an error, but you are conscious of the fact that after all, you're a human being. You're subject to all the failings of a human mind, and you cannot be infallible. But we always had this confidence in the High Court that there was a court above us to correct a possible error. In the Supreme Court, the great challenge is that that you speak as a final court of appeal. There's no court higher than you, and therefore there's no case which I feel in that sense for us in the Supreme Court which is an easy case. Even when you are dealing with, say, an application for bail by someone who is in jail on an allegation that they've committed an offense of cheating or a more serious offense, that you're impacting on the life of the citizen. So in that sense, no case is truly easy. Yes, what you said is true that, for instance, when you decide a case like the electoral bonds case, when the case opens, you're conscious of the ramifications of what you are deciding, and you're conscious of the impact which the case will have on the polity in the long run. It's obviously something which is present to the mind of the court. But when you're deciding the case in terms of the intellectual rigor, as we just referred to a short while ago, you're applying the basic principles which are associated with that body of law. So in the electoral bonds case, we were applying fundamental principles of manifest arbitrariness or the need for transparency in electoral funding. Now, these are not principles which we developed for the first time, but these are principles which have gradually developed over the last 75 years. And that's something which is a hallmark of the judicial process, that everything which happens in a court is in a sense a continuation of what has happened before with incremental changes. So every case is in that sense a new case, but the principles which you are applying to decide that case are principles which have gradually developed over the last 6-7 decades, as in the case of constitutional cases, and maybe over 100 years in the case of civil cases or criminal cases. Yes, some of these cases do pose that issue about how you will decide for the future, because as judges you're conscious of the fact that what you are deciding now will impact on our society for a whole future, and that sort of does constantly remind you as a judge to be humble. Humility is something which you learn as a judge of the Supreme Court, because you're conscious of the fact that the field of knowledge is so vast, and it's far vaster than any of us as judges or lawyers can fathom. So in that sense, you try and derive inputs from members of the bar who are arguing the case. You look at them very objectively, and then when arguments close, that's the time for reflection for a judge, when you're really left with yourself. When a case is concluded in terms of arguments, and you reserve a case for judgment, that's when the real process of judging starts, because then you're just left to yourself. There's no one else with you but your papers, and in our case now this is a digital format, so the digitized files and yourself. So in that sense, judging itself is a very lonely task, and particularly in cases like the one you referred to, you're reminded every day until the final judgment is delivered that it's truly, you're left to yourself. Of course, you have the benefit of colleagues on the bench. So though I delivered a judgment, say in the case of the electoral bonds, It was a 5-judge bench, and you're constantly collaborating, having discussions, formally, informally, with the other colleagues on the bench. So though the judgment is attributed to one person, it's ultimately the product of a collective decision making. Now, what the changes to an original draft are is never disclosed to the outside world, because that's a part of the internal consultative process among judges. But each one of the judges who forms a part of the bench contributes to the ultimate product. The authorship is, of course, attributed to one person who writes the judgment.
Chief Justice, you just said that judgeship is a very lonely process. Leadership, all the more lonely. And you also said that Supreme Court, as one of your colleagues actually wrote, that Supreme Court is supreme but not infallible. And you said that it teaches you a lot of humility. Those are quite different things to wade through. Humility in the task and the sense that you are supreme but not infallible probably go hand in hand, Chief Justice?
Absolutely. You're absolutely right. As they say that, the Supreme Court is final not because it is right, but it is right because it is final. And, that's why we in the Supreme Court have looked at the correctness of some of the past judgments which were delivered. In fact, this year in 2024 and even earlier, we overruled several judgments which were delivered by our predecessors in the Supreme Court in the 1970s, in the 1980s, in the 1990s. And we overruled those judgments not necessarily because they were wrong. Perhaps those judgments may have had some bearing on the society in which they were delivered, in the backdrop of the context in which they were delivered. But those judgments didn't make sense today as society has evolved. So as judges in the Supreme Court, the court itself as a collective unit, as a collective institution, is empowered to look at the validity of its own earlier precedents of the past. For instance, there was a judgment of Justice Krishna, which we recently had a look at again, on property. And the Supreme Court had said that because the individual is a member of the community, every property which belongs to the individual is property of the community in the context of Article 39B and C. Now, this judgment was delivered in the context of the society that we were when it was delivered. A very tightly regulated economy, central planning, all that changed after 1990 when the market reforms took place. And between 1990 and 2024, India has evolved. India has evolved as a society. India has evolved as an economy. So intrinsic to the work of the Supreme Court is the ability to re-look at the judgments of the past. And in that process, I overruled a couple of judgments delivered by my own father. And but that's part of the process. I mean, that's part of the judicial process. Incidentally, they happen to be judgments of my father, but I would have done that anyway as part of our constitutional duty,
But Chief Justice, in one of the judgments that you overruled or overturned, you did pass some observations. And it was said at that point of time that those observations were unduly harsh. And those are not my words, those are words of your peers. Do you think, now that you are saying that each judgment is delivered in a context, in a particular time, situation, setting, do you think you could have avoided those words, Chief Justice?
Well, for one thing, some of the words which are attributed to me as having been actually said in the judgment are not in the judgment. For the reason that maybe those observations were there in a draft which was circulated to colleagues, but colleagues come back to you with a draft. And in this case, after a very well-meaning colleague requested me to look at that particular observation, I deleted it from the judgment. But having again said that, how you phrase a judgment is again a perception of that individual. And I don't believe that, my observations in that case, to say that a judgment is wrong and to say that it is wrong or terribly wrong is not harsh. For instance, one of the judgments which we overruled was the judgment in ADM Jabalpur, which was actually a judgment to which my father was a party. And in ADM Jabalpur, the Supreme Court had said that when a state of emergency is declared, all fundamental rights, particularly the right to life under Article 21 of the Constitution, gets suspended. So there is no right of recourse to the Supreme Court for protecting your personal life and liberty. Now, we overruled that initially when we decided the case in Puttaswamy, where we decided the right to privacy. Now, when we decided Puttaswamy, we said that the judgment was terribly wrong, because the right to life and personal liberty does not originate in the Constitution. Even if there is no Constitution, human beings in a civilized society, in a democratic society, have the right to life and personal liberty. The Constitution recognizes the right to life and personal liberty, and therefore we overruled that judgment.
Probably codifies it.
Yes, that's right. And I think we overruled it, and while we overruled it, we were also conscious as judges of the excesses which took place in the course of the internal emergency which was declared in 1975, because those were years of my growing up. I was in college, I just entered college then, and we were deeply conscious of what had happened. So when we responded to ADM Jabalpur and overruled it, we didn't overrule it, by saying very, simple words that, well, there's a constitutional error or there's a legal error. We were very, very strong about it, because if you feel strongly about an issue, I don't think that, there's any harm in a judge giving vent to how strongly they feel about the issue, using parliamentary language. I mean, there's obviously...
That was your youthful angst coming back of the era of...
It's not just a youthful angst, it's, I think, the constitutional angst, because I just felt that, we had to overrule the judgment.
Not that you don't look youthful anymore, Chief Justice. Let me just put it in perspective.
Sometimes, as they say,
you are a very youthful man.
The looks belie the years.
Yeah. I mean, they say in Latin America that, the years sit lightly on you.
And, particularly the times that we are living in the age of digital media, in the age of social media, does it make the job of a judge tougher because of the kind of scrutiny that you're facing?
Oh yes, of course, because in the age of social media, everything that is said in court now becomes a part of a public dialogue and a process of dissection. Earlier, before the advent of social media, you had 100 people sitting in the court or 50 people sitting in the court, and you had a few print journalists who would be your beat reporters who would be taking down what had to be published. And what went to the press was ultimately what the beat journalist or the beat reporter thought worth publishing for the next day. Now it's no longer like that, because every little word which is said by the court or by a judge in the course of an argument is in social media the next moment. The real challenge is really this, that a lot of conversation which takes place in the court in the course of the hearing of a case does not reflect the final judgment of a case. But, our attention spans are so limited today, down to, the 20 seconds on social media, that people don't understand the distinction between a dialogue in a court and the final judgment of the court. Even before the final judgment of a court comes, people feel that the dialogue is reflective of, your position. And that's not quite right. Sometimes you find that the criticism is extremely irrational. The criticism of a judge, the targeting of a judge, is based not on any concrete material, but just what anybody can say about a court. But these are now, I think, that's a new normal. We are living in an age of social media, and we have to confront the new normal. Train judges to be independent and train judges to be capable of taking their own decisions, uninfluenced by what is being said about what they said previously, maybe in the previous hour or the previous day, in the course of the hearing of a case. But yes, social media is a challenge.
So your tenure in courtroom number 1 was also marked by several judgments with regards to gender justice, minority rights. Decriminalizing homosexuality, for one, has huge impact and has shown the direction to the country as well. When you enter the courtroom for these judgments, what was on your mind?
Well, actually, when you enter the courtroom to deliver the judgment, the judgment is all done and dusted. You already have the judgment in your hand.
Read the judgment.
Yeah, because you're releasing the judgment. But after that, there's a point of no return. Once, you have shared the judgment with colleagues and you're just notifying the judgment and you're going to declare the judgment, The real process is before you actually come to that.
The judgeship, as you call it.
The writing of the judgment.
Yeah, the judgeship, as you called it.
The actual deliberation between colleagues. The process when arguments are going on. Because when arguments are going on in the court, you're reflecting and you're churning, on your thoughts and which way you would possibly go without arriving at a final conclusion. And that's really the very challenging part of, judging. All these judgments that you referred to, and there are others as well, they do, of course, you spend sleepless nights as a judge. I had my own share of sleepless nights, working till way past midnight, waking up at 3:30 in the morning to, sit down when the world is very quiet, when you don't have the pressure of, administrative files, which a Chief Justice of India has to deal with apart from all the judicial work. So, it involves a great deal of reflection. You're questioning yourself. You're constantly questioning yourself as a judge, even before you deliver the judgment on whether what I'm arriving at in terms of the conclusion is a correct conclusion. It's not that, you decide at the end of the argument that, well, this is how I'm going to decide. Very often when you are actually dictating the judgment, or in my case, typing out the judgment on my laptop, that's when you realize that there's a problem in the line of approach which I am taking as a judge. Because when you are, with yourself and you're either dictating the judgment to your stenographer or you're typing out a part of the judgment on your laptop, you realize that this doesn't make sense. I have to modulate what I thought should be the line of reasoning to arrive at this conclusion. And so you're constantly questioning yourself. As judges, I think we are our greatest critics. And you're constantly asking yourself this question: can I write this particular perspective in a different way? Is there a better way to put this, in terms of my reasoning? Because the outcome is for the present. The reasoning is for the future. It's not just for the present. Because future generations of citizens would be looking at how you reasoned in coming to that conclusion. And they would be away from the battle of conflict of today's times, but then they look at your reasoning in the future. So this part is very crucial to the work of a judge.
Chief Justice, one of the leading members of the bar and one of the leading members also of the principal opposition is Dr. Abhishek Manu Singhvi. He wrote a piece in one of the leading newspapers saying that Chandrachud was 90% right, do not troll him. I would see that as a very big platitude. That is a very solid endorsement coming from somebody who's not certainly on the side of the treasury at this point in time, and is a very distinguished man of law. How would you see your own work in light of that kind of commentary?
I would think that it's for others to judge my work. For me, what mattered was that I was true to my conscience and I did my work to the best of my ability. But really, it's for others today and tomorrow to assess the work, to critique the work, and to decide whether it's made a difference to society. For me, if the individual cases which we decided made some difference to society, whether it was having women in the armed forces, I just love it when I see a picture of a woman fighter pilot, or a woman in on the battlefront, or women in the warships, because I realize that that's been transformative to have women now in the armed forces. So that's the degree of personal fulfillment which you have as a judge. But then it's for others to judge and critique whether what you've done is right, whether what you've done is going to transform society, and the future always will take its own call. Sometimes the present can be very complimentary, as Dr. Singhvi was very graciously complimentary. Sometimes the present can be uncharitable as well to judges. But I think once you're away from the present zone of conflict and the polarity of views, the future decides on the contribution of a judge a little more objectively, away from the zone of conflict and the conflict of ideologies.
In terms of your chapters, your own life chapters, how many more to go, according to you?
I mean, what's next? Let's put it like this.
You know, over the period of the last 65 years, I've learned one thing, and which is to live in the moment. Because life is very short. Every breath which you take is truly a blessing. And I've learned, you know, to live and focus in the present. So I'm very happy with where I am at present. Not having, you know, all those enormous responsibilities of office, which were great so long as it lasted. But now that it's time to move on, I've moved on. And I've realized, you know, that the last 25 years have seen such a radical change in our society. And it's now time to sort of savor those changes, be part of the life of society as a private citizen, interact with people, interact with young people. So what future chapters there are going to be, I think only the future would tell me. But I love to live in the present moment. That's my motto of life.
Let me also ask you something that was fairly contentious during the years preceding you in the top chair Chief Justice, and that was, you know, the observers wrote, these are not my words, observers wrote that there was a phenomena engulfing India's Supreme Court, and that was judicial evasion. Many neutral observers have commented that it was your advent on the top chair that judicial evasion was finally confronted, and you stopped that practice and you bit that bullet. Do you think that at the Supreme Court of India, which is the last court of appeal, there is a scope or position that the judges can take of evasion? Is that luxury available to them?
Actually, it would be uncharitable to the Supreme Court as an institution to say that, well, it evades cases or it evades deciding cases. The court has 34 judges. Today, it's not a court with full strength. Now, there are about 80,000 cases which are pending. This is a great challenge for any head of the institution, which is that do you take up the smaller cases which involve a big impact on the lives of common citizens, maybe a civil appeal, a criminal appeal, a bail application, or do you take up, say, the seminal constitutional cases? Because there is a trade-off. When, say, 5 or 7 or 9 judges are assigned by a Chief Justice to deal with a constitutional case, those 5, 7 or 9 judges are not dealing with the ordinary work of the court, right? Now, some balance has to be drawn by the head of the institution of how many judges would you devote to doing the normal or routine work of the court, which is important in itself because you're dealing with the lives of individual citizens. But equally, this is not just a court of appeal. It's a court which is a constitutional court. And you have to devote sufficient resources and human manpower to dealing with the important constitutional cases as well. So in my 2 years as Chief Justice, I decided that, well, I will place great importance on both aspects, on ensuring that we deal with the normal flow of litigation. So, you know, every week a judge would be reading, say, 70 or 80 cases on a Monday and again a 70, 80 cases on a Friday. But then Tuesdays, Wednesdays and Thursdays, we would sit in the Constitution bench and deal with some of the important constitutional cases. So it's a tough call, really, for the head of the institution, because you have to have one eye on the inflow of cases which is coming into the court. Last year, that is 2024, 59,000 cases, close to actually 60,000 cases were filed in the Supreme Court. It is unprecedented. I mean, this is the largest filing since independence. And the Supreme Court disposed of over 59,000 cases. So notwithstanding the fact that we have the Constitution benches growing through the year, we disposed of almost as many cases as were filed. So this is really a trade-off. But as I said, it's critical that, you know, we as a court also deal with the important issues of the time. Speaking for myself as a judge, this was a learning lesson which I learned from the Bombay High Court, where I cut my teeth as a young judge, which is that once a case comes to your hand, you must conclude it. And this was my mantra throughout my judicial career, that once the case came to us, then usually we wouldn't really adjourn it without a very good cause, and we would take that case from beginning to end. And that's what we did, whether it was in, so many of these Constitution Bench cases that we decided were cases which were pending for a long, long time in the Supreme Court. And obviously you can't deal with all of them, but I tried to deal with as many of these cases as I could. But I don't think it's really a matter of judicial evasion as such, when a case cannot be taken up by a court. Some of my predecessors, for instance, if they couldn't take up a particular case, it was not an act of judicial evasion. It was just because of the pressure of work. I mean, it's only when you're a Chief Justice of India and a judge of the Supreme Court that you realize the enormous pressure of work, just the volume of work, pressure in the sense of the volume of work which you have to handle. So this is a big challenge of how do you balance the two.
Well, Chief Justice, that brings me to the last question probably, unless Maria has something else to ask. And that is that in terms of work and in terms of leaves, Supreme Court has faced sometimes undue criticism, I would say, about the leaves that the Supreme Court has. And I have spoken to some very distinguished lawyers like Mr. Chidambaram, and they said that, and he has actually written it in the public forums also, that leave is actually not leave. That is consumed for many purposes of writing those lengthy judgments, going through the court papers, etc., etc. Do you think that the world at large needs to be sensitized more towards the vacation of the Supreme Court per se, so as to, for them to appreciate that process better, rather than plainly shoot at the Supreme Court for just having too many leaves?
Absolutely, I completely agree with you, for the reason that even during the summer, say commencing from the 15th of May or the 20th of May to the 1st of July, it's a partial court working period. The court does not close its shutters. Even during the summer, first, at least 3 benches of the Supreme Court are doing regular judicial work, and they're constantly doing judicial work. Even during the time of the COVID lockdown, there was no lockdown in the Supreme Court. We all worked online. So the Supreme Court has never been closed. That's the first important thing which is to be noted by viewers. The second important thing is that all judges of the Supreme Court, and I've been there for close to 9 years, from May of 2016 till I retired, 8.5 years, all judges of the Supreme Court worked from Monday through Sunday. There are no weekends for Supreme Court judges, because on Saturdays and Sundays, you're doing 2 things. You're reading for the Monday cases, 70 or 80 cases, and you're delivering judgments which have been held back in reserve, either that week or the previous week. In the summer, the so-called summer vacation, it's not a vacation. I know, as a matter of fact, that some of the critical constitutional cases, or the more important cases, they may not be constitutional cases, but these would be cases involving important questions of law, which have been kept back for more reflection. They are the cases which are dealt with in those vacations, when judges would sit down, read the papers again. Say you have a batch of, I had a batch, for instance, of say 700 cases involving a question of income tax law. Now, when do you actually read those cases? You can't read them during term time, because there's just too much of work which is going through your office and through your hands during term time. It's only when you have a mini break or a longer break, say a mini break like for Holi or for Diwali, that judges get down to doing all this work. And third, it's important to understand that what is the Supreme Court for? Is it merely to sort of, have a statistical analog of cases disposed of? Or is the function of the court to make a difference in society today and for the future? If it's the latter, you also have to give judges enough time to think and to understand what the impact of the decisions which they are going to make will have. And this is not in the case of politically important cases only, or the constitutional cases. This is also in the case of the economically important cases. An important case, say, in electricity law, or arbitration, or securities law. An important decision, say, the securities law would impact the securities market. An important decision in electricity law would completely alter the framework of private participation in the electricity sector, or arbitration, as I gave you an example of. So judges must have the time to think. It's not a mechanical job. It's a job where crucial cases can go either way. You have two sides which have made an equally plausible argument. So unless you give judges time to think. And the fourth point which I want to make is, our Supreme Court is among the Supreme Courts in the world which has the longest duration of working days. There are Supreme Courts in other parts of the world where if a judge sits for a week on hearing cases, they would get a week off to actually deliver judgment, think about the case, craft the judgment. But we have no such luxury. Our judges work continuously. In fact, another colleague who just retired shortly before me was telling me that, it's after you've laid down office that you realize how much you have internalized the stress of having to work on this relentless flow of cases. So all in all, I think the criticism that the court has too many vacations is completely unfounded, because it doesn't, it's not justified by what is the truth, which is that judges are working 24/7, 365 days. Occasionally, judges would go out of town, but even when they go out of town, say on a Friday evening and come back on Saturday, they are addressing students of law colleges, they are conducting legal aid camps. So that's equally a part of the functioning of a contemporary judge. So it's not that judges have, unlimited time off or, time to spend with their families. In fact, I know as a matter of fact that the first victim of a life on the bench is your own ability to spend time with your own family. So I'm making up for lost ground now, that I'm...
So Chief Justice, let me compliment you before we close, that, I don't know whether you would have been a Nobel Prize winning economist if you would have taken up that study, but you certainly can be, and that future certainly lies in front of you, is that you can be a very, very, very beautiful speaker.
Thank you. Thank you so much.
Thank you so much for your time here on NDTV.
Thank you very much. It's been a pleasure to be engaging.
You can think of platforms like TEDx, now going ahead, Chief Justice, for speaking.
Thank you very much.
Hello, Moto.
Motorola Edge 50 Pro, world's first AI-powered pro-grade camera.
Kumbh, a festival of faith, the world's biggest spiritual festival, the divine dip at the spiritual Sangam, a sacred confluence of faith, culture and heritage. NDTV's mega coverage of the Mega Fest. NDTV at Mahakumbh 2025.
We are able to maintain the democratic fabric and the democratic system.
I want to do something that can make a difference.
लगातार जनता की आवाज को सरकार तक पहुंचाने का काम मैं करता हूं.
I was a student up until very recently. I really want to work and do something for my people because they have given me this opportunity. They have elected me.
सोचा नहीं था कि राज्यसभा सांसद बनूंगी.
Kind attention, please. Delhi Election Metro 2025 is arriving on people's platform. Please mind the gap. BJP or AAP, who will get to the Delhi Secretariat station
दरवाजे बाईं तरफ खुलेंगे.
Who will Delhi voters open the victory doors for? And who will be shown the door? Can the BJP throw AAP's victory run off track? Or will it be Kejriwal's ticket to win again? Can Congress take the election metro to revival? We will track it all for you. Delhi's decision destination. Doors will open on the left. Stay tuned to NDTV for mega metro poll coverage.
I've been reporting on all issues, big and small, from Andhra Pradesh, Telangana, rest of South India.
US President-elect Donald Trump posted a controversial map depicting Canada as a part of the United States and suggested that Canada could become the 51st state. He also hinted at using economic force to acquire Canada and expressed interest in purchasing Greenland. This elicited strong reactions from Canada, and as Trump advisor Elon Musk has been targeting Europe.
This is not the new map of the United States. This is another instance of Donald Trump hinting that Canada could be taken into US territory. Sending shockwaves across the globe, the map shows the whole of Canada as part of the US. The US-Canada boundary is the world's longest between two countries. It was established in treaties dating back to the founding of the US in the late 1700s. Trump claimed the US spends billions of dollars protecting Canada, while criticizing imports of Canadian cars, lumber, and dairy products.
You said you were considering military force to acquire Panama and Greenland. Are you also considering military force to annex and acquire Canada?
No, economic force. Because Canada and the United States, that would really be something. You get rid of that artificially drawn line, and you take a look at what that looks like, and it would also be much better for national security. Don't forget, we basically protect